friends, pull up a chair for our new monthly YouTube series, Sharing with Friends, where every month we're going to be chatting with different professionals, different guests on topics that support the Down syndrome community. And so we're super excited to launch this very first conversation. And we have with us Jeff LaClair. Jeff is a partner at Phelps LaClair. He focuses his practices in the area of estate planning, taxation, wealth preservation, planning, and business succession planning. So he also has a love and a particular interest in helping families with special needs children. So today's conversation is going to be all about estate planning for those in your life who have special needs. And we're going to just break down this conversation one bullet point, one topic at a time. So Jeff, thanks for being with us today.
Thank you for having me.
Yeah, so let's start off by just talking a little bit about your background. So tell us a little bit about you.
So I was born and raised in Michigan, and then actually kind of went to school in Florida and New York before I moved out to Arizona about 11 years ago. And so, yeah, once I settled down here, I was fortunate enough to essentially participate in sharing Down syndrome. Growing up, the actual high school I went to, there's a lot of individuals with disabilities within the high school, so they did Special Olympics, and that's when I started working with the community. And then out here it's just been great to be able to be a member of sharing Down syndrome.
That's awesome. And so you've really had, it sounds like you've had a deep love and passion, for the special needs community for quite a while. And I think it's awesome that you've been able to have the opportunity to get involved, with different organizations, including Sharing Down Syndrome Arizona. What has that meant for you? I'm just curious.
I think it's been really neat just to be able to help the families that are involved with sharing Down syndrome. Growing up, my best friend's brother had Down syndrome, so from a young age, I understood really the impact that it had on his family in particular. And so now being able to help families plan for worst case scenario.
Yes. Yeah, and I think that's great because I feel like a lot of people just in general really don't know where to even begin in that area. So like I mentioned, we're going to talk about estate planning, kind of just an overall view of what that looks like, maybe some best practices. So my first question would be for Jeff is where should families start? Where do we begin when it comes to estate planning, in particular estate planning for children or adults even in our lives that have special needs?
Yeah, I think the most important thing is putting a plan into place. I think a lot of times when I work with clients, one of the biggest hesitations is they don't know where to start.
Yeah.
So there's that hesitation in even getting the process started. And so I think, whether they want to go meet with an attorney who specializes in that or even speak to somebody who's done it before. But I think that's really the first step, is just getting the process started.
Okay. So then once someone decides that is in fact what they want to do as far as setting up parameters or whatever that looks like for estate planning. Once they decide that, okay, I'm going to have this conversation, I'm going to reach out to this professional, I'm going to get a consultation, with an expert in that field, what does it look like? What's the next step after that? What should they be thinking about?
Yeah, I mean, the process itself is pretty simple. I think that's another thing that people hesitate in getting started because they think it's going to be more overwhelming.
Yeah.
And a lot of people tell me, once they start the process, they're relieved by how easy it really is. And so really the first step, the way we handle it at my firm is it's a free initial consultation to get to know the family.
Okay.
And then we kind of talk through their situation and explain what options they have. And so it's pretty laid back and an easy process to get started.
And I feel like it can be daunting, because I was even telling Teresa, I was sharing with Teresa that I learned over the last, actually it was probably about 3 weeks ago, I was at a conference and they were talking about estate planning and trusts and living trusts, and I had no idea. And it felt, even in that conversation and hearing what they were sharing, it almost felt a little overwhelming. Like, how do I, like, I know this is what I want to do. I want to get this set up, for my children, for my family, but it's like taking that step to understanding what do I need to gather on my end and prepare for in order to get that kind of rolled out. So I guess my question would be, for a family who is thinking about estate planning and getting that all in order, is there anything that they need to do on their end prior to meeting? Let's just say you, for example, say I want to come to Jeff and talk about estate planning. Is there anything that I need to gather on my end to do that?
So for our clients, we do provide an initial questionnaire.
Okay.
Just to gather some personal information about the family. But there's really not much work to it, because in our initial meeting, that's really where we'll sit down and go through all the details of their particular situation. So there's really not much work on the front end. That's really our job in the initial consultation, and understanding what the family dynamics are and gathering that information.
So let's dive a little deeper. Let's go into some of what those items are when you're thinking about estate planning. So what is a special needs trust? Like, what is it? And kind of take us through what that looks like.
Yeah, really the special needs trust, or some people call it a supplemental needs trust, it's really just a technique or a vehicle that's used to set aside resources for an individual who has a disability.
Okay.
And the purpose behind that is, if an individual does have a disability, they may qualify for, we'll call it needs-based benefits, where the government would actually look at that individual's resources to determine whether they qualify for benefits. So that's one of the biggest risks, is if an individual who has a disability is receiving needs-based benefits, and then all of a sudden they receive an inheritance from a loved one, whether it's a family member or a friend, those resources would go to that individual. So now all of a sudden they would be disqualified from receiving those benefits. And I think that's one of the scariest aspects of it, is because a lot of times that individual has spent years applying for the benefits that they qualify and that they need. And that process itself is very difficult on the families. And so all of a sudden, even a small inheritance of a few $1,000s could disqualify them from receiving the benefits. So the idea with the supplemental needs trust is you can set aside resources that are made available for the individual, and those assets or resources of the supplemental needs trust aren't considered a resource of that individual. So it allows them to preserve their benefits. So really the assets are there to supplement what the government's not providing for.
Okay.
And so it's more just a technique to make sure that an individual who does have a disability is going to be adequately provided for over and above what the government would normally provide.
So then if I have someone in my life who has special needs and I'm thinking of estate planning and setting up, different provisions for them, should I be thinking about then a supplemental needs trust in addition to something else, or kind of talk us through that a little bit?
Yeah, I think the best way to explain estate planning overall is it's kind of like an umbrella.
Okay.
And underneath that umbrella, you're going to have different tools for the estate plan. So as the foundation, you would normally have what's called a revocable living trust.
Yeah, I've heard of this.
And so that's kind of the starting point in essentially putting assets aside. And that one of the benefits of the revocable living trust is when we do pass away, if we have assets in a trust, now our family and loved ones don't have to go through the probate process of passing those assets on. And then as part of the revocable trust, that's where you can build in a supplemental needs trust if you're looking to provide for an individual who does have a disability.
Okay, so it's kind of like a tree. I think of a tree for some reason, like you have branches, like you have the big tree and then you have branches of the tree. So then, a revocable living trust, and then within a revocable living trust, you can set up a supplemental needs trust within that?
Correct.
Okay. What other trust should we be thinking about then? I mean, you explained the revocable living trust. Is there other trusts that we really should keep in mind?
I would say one of the more common trusts would be, they call it's an inheritance trust.
Okay.
So if you're looking to provide for an individual, and we're not concerned about preserving government benefits, the other concerns out there are more protection from third parties. So if a beneficiary ever has a lawsuit, creditor, divorce, if you set up the estate plan properly, you can actually protect the inheritance from third parties, such as those.
Okay. So then all of these individual trusts within the big umbrella, I mean, you could set up various things within the big picture, right?
Correct.
Yeah. Okay.
And I think that's why the estate planning is so important, is every family's unique.
Yeah.
And so you may be working with a family who has 5 or 10 children, and each one of those children will have their unique circumstances. And so by doing the estate planning up front, you can really plan for each one of those individuals in the circumstance that they're in.
Okay. Let's talk a little bit about, Teresa and I were chatting earlier, and let's talk about how might a trust that you have set up affect SSI or SSDI?
Yeah, so the benefits that are provided through SSI are going to be based on essentially resources. And so the important thing is, if you have assets in a supplemental needs trust, those assets are not going to be considered a resource when they're looking to apply for SSI benefits. Whereas SSDI benefits, it's actually based on the underlying disability. So really, resources are not a factor in determining whether somebody qualifies for SSDI.
Yeah.
I think sometimes the problem is an individual may qualify for both types of benefits. So you just have to be very careful that if it is based on resources, that those assets are in a supplemental needs trust, so they're not disqualified from receiving those benefits.
So Jeff, we were talking about a little bit about the ABLE Act and how it's an effective savings vehicle and really an effective tool for people with special needs and families. But talk us through a little bit about, one, what is the ABLE Act? And then 2, what are the different elements that we should be thinking about when it comes to that provision?
Yeah, so the ABLE Act, it was enacted at a federal level that essentially allows monies to be set aside into an ABLE account. And it's very similar to a 529 account. The difference is, with an ABLE account, it's set up for an individual who has a disability, and it allows monies to go into that account, and the money within that account is not subject to income tax. So as the monies can be invested, it provides essentially a tax-free savings option, similar to a 529 account. And I think the best thing about the ABLE account is it also provides independence to the individual, where a lot of the programs that have been enacted through the states will allow the individual to have access to a debit card. So if they're going out with friends or something like that, now they can use the debit card and learn how to manage money and so forth. But yeah, so I think it's a very effective tool and very practical to be used. But yeah, I think because of the issue with the monies remaining in the account being subject to the claims of the government, it's not going to be a replacement for a supplemental needs trust.
Okay.
It's usually used in connection with a supplemental needs trust.
So it's an additional tool outside of a supplemental needs trust that parents should really key in on, or
Correct.
Individuals should really key in on. Okay. Okay, so we're going to kind of go back to talking a little bit about some of the trusts. So if I was a parent, well, I am a parent. I am very much a parent. But if I, if I had a child with special needs in particular, how should I think about leaving my inheritance to my child with special needs? And we've talked a little bit about an inheritance trust and the revocable living trust and the supplemental needs trust, but let's kind of dig a little bit more into that. What should I be thinking about?
Yeah, I think the two primary considerations is going to be addressing guardianship.
Okay.
So if something does happen to you, as far as who you'd want the child to live with, and I think that's probably one of the most difficult decisions to make, to think about if we're not here, who would watch after our children. And so that's one aspect. And then the second aspect is more the asset management, as far as, you know, being able to choose somebody that you know and trust to oversee those monies if you're not there. And so, you know, sometimes I'll work with families who will choose the same person to be both the guardian and the trustee over the trust. Whereas some families, you know, may look at it and say, well, I would trust my sister to take care of the children, but, you know, she's not good with finances, so I'm going to choose my other sister who is. So I think those are really the two primary considerations.
Because that's good to know, because you really can designate then, it sounds like, different individuals for different parameters within the trusts, right?
Correct.
Okay. So then what about adults with special needs then? Let's say, you know, my child is an adult. So does it still work the same way?
Yeah, most often it does, especially if that individual, the adult child, if you had already gone to court to get guardianship to be able to make the medical and financial decisions, then as part of your estate plan, you would be able to designate who you'd want to take over guardianship if you're unable to do it. So really the planning would be the same as to whether the child is a minor or an adult.
Okay. I had a question. I was thinking recently about wills versus trust. So what should we be thinking about when it comes to setting up a will versus setting up a trust? Like, kind of take us through that.
Yeah, I think one of the main issues that I see clients have is that they think that if they set up a will, the will is actually going to avoid probate court, which is not necessarily true, because if the value of assets passing through a will exceeds $75,000, the will still has to go through probate court to distribute the assets. So I think a lot of people are misled thinking that I need to set up a will to avoid probate. But the unfortunate reality is most wills do have to go through probate.
That's really good to know, because I mean, even I had that misconception in a way, like if I have a will and I'm very specific in my will, then I'm good. But yeah, it sounds like because the over 75,000 in assets, that's really interesting. I had no idea about that. Okay, so really then people really need to think about, I mean, should you have both then? I mean, how does...
Yeah, so if you're going to utilize a revocable living trust for your estate plan, we always do. It's called a pour-over will, and it's really just there as a safety net. And it just says that if I were to pass away and there's assets that are not in my trust, then my will is going to pour those assets to the trust. But again, if we're utilizing the will to transfer assets into the trust and those assets exceed $75,000, the pour-over will still has to go through probate court.
Got it.
And I think that's why it's so important is when you do set up a revocable trust is making sure that it is fully funded, meaning that all of the assets are actually transferred to the trust. And that's something we often see, unfortunately, when clients come in with an existing trust, is even though they spent the time and money in setting up the trust, it was never actually fully funded. And now if we have assets outside the trust, we would still have to go through probate. Getting the trust funded up front, and then also as things change over the years, you know, we talk about best practices, but for our clients, we usually like to review it at least every 3 years, just to make sure that any new assets that were acquired are titled in the trust.
Okay, so it's almost like making sure that those assets are continually transferred over into the trust and nothing is lingering on the outside.
Correct.
Okay.
And usually we'll tell clients too that if you think about it of estate planning, you know, estate planning is really going to be a process that is going to continue throughout your whole life. It's not going to be a single event.
One and done. It's not going to be like a one and done. I'm having my meeting or consultation. I'm setting up my trust, and then it's good. I can just leave it there. Yeah. Like it's something that you have to revisit through your lifetime as long as you're living then.
Yeah.
That's really good to know. Okay, so then let's talk about funding a special needs trust then. Like, what does that mean? How do you fund a special needs trust?
So the most common funding when you're doing a supplemental needs trust that's created through a revocable trust is that funding would not actually incur until the creator of the trust passes away. So really the funding is going to be the funding of the revocable trust up front, and then when the creator of the trust passes away, then that's when the assets would then be transferred or funded into the supplemental needs trust.
Okay. So when we're talking about funding, I saw somewhere, just an example, life insurance, retirement, savings. Are those kind of the things that you would think about when funding a trust?
Yeah, and I think the best way to think of it is anything that actually has a documented title, whether it's real estate, vehicles, bank accounts, investment accounts, anything that actually has a title should be titled in the name of the trust. And then there's going to be a major exception in dealing with retirement accounts. But yeah, usually we start with the general rule that for all assets that have titles, we'll want those assets to be titled in the name of the trust.
So even if you have like stocks or bonds, anything, they should be going into that trust.
Correct.
Okay. Yeah, this is great information, Jeff. Yeah, this is good. As we close out, what else do you want to share with us? Is there anything else, any final tips, best practices, anything else that you want to touch on before we head out?
Yeah, I think one of the things when it comes to estate planning is it's never too early to start. A lot of times I'll have clients ask me, do I have to have a certain amount of assets to justify doing an estate plan? But I think the best example would be for anybody who's 18 or older, it's really necessary to have powers of attorney in place for both medical and financial. And I see that oftentimes with clients where their children will go off to college, and now all of a sudden the parents call to make a tuition payment or to schedule a doctor's visit, and now all of a sudden they're told that the parents can't do it anymore because their children are 18. And so that's usually when it prompts the parents to encourage the children. So a lot of times people think, am I too young to do estate planning? And the reality is if you're 18 or older, you really should have some type of an estate plan in place to address incapacity planning.
That's really good to know because I have a daughter who just turned 19. So then you're saying that she really could, she could have her own trust in place?
Yeah,
what are the steps of that, of making that happen?
And so it's not necessarily that she may need a trust right away. It's just, and I hate to bring it up, but if there was an accident and now all of a sudden, she's unable to make medical decisions for herself, even you as a parent don't have the legal authority to make those decisions. And so I've seen it happen.
Wow, that's
even happened to my cousin. He ended up getting into an accident and he didn't have powers of attorney in place, so his mom had to fly across the country and go through the guardianship and conservatorship process just to be able to make medical decisions for her son. So that was a situation where it wasn't necessarily a need for a trust. It was just
so the power of attorney, that whole process of setting it up, then would it look like kind of the same process of either having that set up with an attorney or
at the end of the day, you can think of best practice as doing it with an attorney who is familiar with state laws to make sure that it's compliant. But at the end of the day, any estate plan is better than no estate plan. So even if it's for people who are looking to do it, like the county, Maricopa County provides forms for powers of attorney. So sometimes I'll have clients that'll utilize those just to make it simple, especially if they're doing it for their children.
So Jeff, if I wanted to get in touch with you and basically, learn more, the consultations are free, right?
Yes, they are.
And how can someone get in touch with you?
Easiest way is if you just call the office and we can schedule the free consultation, or if you want to go to our website to learn more about the firm or just estate planning in general, you can always use the website as well.
Okay, awesome. Well, this has definitely been a great conversation, Jeff. Thank you so much for joining us.
Yeah, thank you for having me.
And thank you so much, friends, for plugging in. We're going to have many more in-depth conversations surrounding just really great topics that impact family, that impact, your life, that impact those around you with special needs. And so we can't wait to dig in deeper into sharing with friends and have you pull up a chair and join us. So make sure to tune in to the next Sharing with Friends. And in the meantime, I'm going to link Jeff's information in the description of the channel. And yeah, thanks again, Jeff. You've been great.
Thank you.